This communication is made available by Colorado Legal Services as a public service and is issued to inform, not to advise. No person should attempt to interpret or apply any law without the assistance of an attorney. The opinions expressed in this communication are those of the authors and not those of CLS or its funding sources. This presentation is designed to give you a basic idea of how the court system works in Colorado. Municipal, state, federal, and administrative courts each have an important role. Different types of cases are filed in different courts. This program will not cover criminal, traffic, or juvenile matters in any detail, nor will it cover Colorado's water court system or water cases. This program will also briefly describe alternate dispute resolution. Why do we have courts? Courts exist to apply and interpret the law, state constitution, and U.S. Constitution when parties disagree. They resolve disagreements between individuals, groups of people, companies, and units of government. When you buy or sell goods or property, get married or divorced, have children, work, retire, drive a car, and even after you die, your state courts can protect your rights and enforce your responsibilities. If you are a victim of a crime, are accused of committing crime, or a witness to a crime, you may be required to appear in a Colorado court. The courts and the protections of the law are open to everyone. What is the role of the courts? The roles of the courts include holding trials that determine the guilt or innocence of persons accused of breaking the law, resolving disagreements involving civil or personal rights, interpreting the Colorado and U.S. Constitution and constitutional provisions of the law enacted by Congress and the legislator, deciding what is the law when none exists for specific situations, determining whether a law violates the Constitution of the United States or the state of Colorado, providing supervision of offenders placed on probation instead of serving jail time where appropriate, and providing appellate court review for decisions of lower courts. Colorado courts are divided into 4 distinct court systems: local or municipal courts, state courts, federal courts, and administrative courts. State courts handle over 95% of the cases in Colorado. Traffic offenses, misdemeanor, and felony criminal offenses, divorce, wills and estates, buying and selling property, and other cases similar in nature are governed primarily by state laws, so they are heard in state courts. Federal courts handle such cases as bankruptcy and those involving federal law or federal government agencies. State and federal courts are both generally divided into 3 levels. Most cases start in the trial courts. In Colorado, these are our county and district courts. Appeals are usually heard first by the Court of Appeals. The Supreme Court is the court of last resort and has final authority on the cases it hears. In most situations, Supreme Courts have the right to refuse to hear a lower court decision. Almost all court matters start in trial courts. There, judges and/or juries listen to witnesses, resolve issues of fact, and apply the law to the facts of the case. The result is a decision, also called a ruling or order, in favor of one party over another. County court is a court of limited jurisdiction, handling civil cases of under $15,000, small claims, misdemeanors, criminal traffic violations, civil traffic infractions, and felony complaints, which may also be sent to district court. All 64 Colorado counties have county courts. Also, county judges issue search warrants as well as restraining orders, called protection orders in Colorado, in cases involving domestic violence arrests. In county court, after a decision is issued, a dissatisfied party has the right to have an appeals court review what the judge and jury did. In most cases, the district court acts as the appellate court for county courts. What is jurisdictional value? Determining jurisdictional value requires that you place a dollar amount on the judgment you are seeking. The jurisdictional value of your case will be one factor in deciding in which court to file. You can only ask for equal to or less than $15,000 in county court. An example is if you were suing your landlord for more than $15,000 in repairs you made to his or her property, that case would be filed in district court, not county court. If you are suing a person or business in small claims court, you would only be able to sue for $7,500 or less. Otherwise, your case would have to be filed in the county or district court. We will talk more about the different types of courts shortly. District courts. If the case is a civil claim under $15,000, a divorce proceeding, an appeal from a county or municipal court, a review of a decision made by an administrative board or agency, a mental health issue, a juvenile matter, a probate issue, a felony criminal matter, or a water case, the case will go to a district court. Colorado residents in its 22 judicial districts are served by the district court in their area. District boundaries are the same as county boundaries, except that some districts include one county and others include as many as 7. Denver is the only district in Colorado that has separate probate and juvenile courts. If the case in district court was not an appeal from a lower court, after a ruling is issued in the district court, a dissatisfied party has the right to have an appellate court, in this case the Court of Appeals, review what the judge and jury did. Intermediate courts. A dissatisfied party has the right to have an appellate court review the actions of a judge and jury. This court must hear every appeal properly presented to it, guaranteeing that a participant's case is reviewed at least once. If the case is an appeal of a judgment or order from the district juvenile or probate courts, the case goes to the Court of Appeals. This court serves to correct legal errors that happen at the trial court level. Appellate judges decide whether the trial process was fair and whether proper legal principles were followed. In most cases, the district court acts as the appellate court for county trial courts. The Court of Appeals is the reviewing court for district court cases and matters beginning in administrative agencies. Appellate courts serve as a check and balance to the trial courts. Review of a trial court proceedings and the law applied there helps the appellate court determine whether the trial was fair. Remember, the appellate court does not retry the facts of the case. It must accept the facts that were ruled on by the trial court, except in unusual circumstances. Courts of last resort. Following a decision from the first level appellate court, a party can request review by the Supreme Court. This court gets to decide which cases it wants to hear, with some exceptions. Normally, this court hears matters of great public importance or those that have an effect on the court system as a whole. This court reviews transcripts of the trial proceedings and then determines what the law is or should be for that particular matter. Oral arguments directly to the justices are sometimes conducted in these cases. Sometimes, with cases involving important constitutional issues, there may be further review by the U.S. Supreme Court in Washington, D.C. Alternative dispute resolution. Some domestic relations and civil cases can be settled through alternate dispute resolution, or ADR, which includes the use of such tools as mediation and/or arbitration rather than litigation in court. Mediations and arbitrations can be court-ordered or voluntary. They can be a very effective way to settle a disagreement, often saving time, resources, and money. However, most cases go through the formal court system, which follows the strict trial and appellate processes explained in this program. Administrative courts. If you have a disagreement with a state or federal agency, such as Medicaid or Human Services, your case may be heard and decided by an administrative law judge at the Office of Administrative Courts. The OAC is an independent agency within the executive branch of the government and is not associated with any government agency that could be involved in your case. Appeals of decisions coming from the Colorado Administrative Courts are heard by the Court of Appeals. Colorado's court system is divided into 22 judicial districts. Where you live, what type of case you have, and other specifics of your case will determine where and in which type of court you file. Go to these websites on this page to find out more information on state, federal, and administrative courts, as well as to access free court forms and instructions. Thank you for using this Colorado Legal Services presentation. Please take a minute to complete a short survey so that we may continue to provide you with the best assistance possible. Funding for this project was provided by the Colorado Bar Foundation.